kino kirekana nnyo kino kyali ku lwewa mpozi kino
nawe mukulu
Lord me.
Wow, na. Abana baranzi bangabao. Bagaji sawa na muzuri wa.
Ndio ndani kama.
No.
I am appearing together.
First, my age is 66, not 56. The correction can be made. And what I'm charged of is not true.
Plea of not guilty is entered.
Your Worship, the inquiries in this matter are not yet complete. We are going to commence
Very please, Your Worship, I have instructions to apply for bail. Ground number 1, the accused has got a constitutional right which is duly guaranteed under Article 23, Clause 6 of the Constitution. And it should benefit from that right. 2, the presumption of innocence, that as of now, the accused person is presumed innocent until proved otherwise. That is a constitutional dictate, Your Worship. Your Worship, if you would permit me to cite what 2 authorities for that, which I think would... Because I wanted to substantiate the ground with the authority, Your Worship. Most obliged. Ground number 3, Your Worship. The accused has got a permanent place of abode particulars of which are given in the charge sheet. I don't need to elaborate. And therefore, there is no likelihood of absconding from the jurisdiction of this honorable court. Number 4, the accused person is a national leader whose record, Your Worship, is well captured in some of the records before court. He's been a presidential candidate for 4 times. With the performance which is well on record, Your Worship, and not disputed.
Please proceed and make this question the grounds that are already.
Most obliged, Your Worship. He's been a head of a political party which is registered. That is the Forum for Democratic Change. Your Worship, ground number 5, there is no evidence that is likely to interfere with the investigations, and I have authorities to substantiate that ground. Number 6, there is no record that he has ever absconded bail. And related to that, court has not indicated that he has gotten other charges where he has been granted bail and failed to honor the conditions set by court. The last ground, Your Worship, he has got substantial sureties who are ready to be bonded by this honorable court. And if it may please Your Worship, I would proceed to present them.
How many sureties does this person have?
We have 2. Surety number 1, Your Worship, is Honorable Wafrogut. Your Worship,
The names and age.
the age, yes?
69.
Wafrogut. There,
Council guide your surety to group of residents.
okay, particulars of your residence,
Asiteni Itinda,
which zone?
village 14.
Village 14 in Timber. That is Nakawa division in the Kampala city. The relationship with the accused?
He's my leader, he's my friend.
Please be loud.
He's my leader and a friend.
Why did you for a living?
What's your occupation?
Well, I'm a retired journalist, a retired politician, a businessman.
He's a former member of parliament for Bukoli
Central.
and also former leader of opposition in parliament. And for the record, Your Worship, He has another residence at Chitetika LC1 zone. And we have his national ID and the LC letter with the photo. Yes. Telephone contact?
0756 2060.
Harold Scandinavia. Scandron Harold Kaija. We could have mixed it up in other documents because we had to separate the two files. We learned that the files are separate at the 11th hour. So probably our colleague has gone with the photocopy in the other court with the national ID. Oh, wonderful. Your Worship, will be pleased to grant the accused person non-cash bail, considering the circumstances of the matter, the record of the accused person in the first case, and also the fact that it's past banking hours. So if court orders that we pay cash, it will be a negatory order. It can't be paid now. That would tantamount to denial of bail if that condition is set. If it may please Your Worship, I indicated at the outset I have some authorities.
Please share the authorities with the state and share with us.
How about getting the principals?
I'll read the principles.
How about citing the, for record purposes, Your Worship? Most obliged. I rest my case.
Ground number 4 was the fact that the accused person is a national leader, whose record is well known by its honorable court, and we premise our reasoning that more reason that he should refrain from the acts such as the ones he has been charged with of inciting the masses, being a national leader, lead by example, and this should not even arise as a ground for grant of bail, because he ought to have acted as a national leader and not engaged in the acts of incitement as charged. Still in relation to the same, ground number 5, the applicant, who is lawyer, referred to the fact that there's no evidence of any likelihood to interfere with witnesses. We still hint our response to the fact that he being a national leader, it's just enough to confirm that he has the capacity to interfere with our witnesses. As we had intimated earlier, that the investigations are still ongoing. his stature in society alone, is enough evidence that he can interfere with our witnesses. Your Worship, the surety is presented by court. Surety number 1, informed court that is a resident of Ntinda, village 14, in the 3rd division. Your Worship, we are furnished with a letter of LC1, Kazon, which is in Kasangati Town Council, wherein the LC1 chairman indicates that he has a fixed place of abode. I have also looked at the national ID. It was issued in Bujuli district. Your Worship, as it stands, the surety, as the first surety, Mr. Wafula Obutu, fixed place of abode is not known to us. It's ambiguous and not clear because he has three different places from which he hails. Your Worship, we don't want to victimize the surety. We shall request as prosecution that he confirms this place of abode of Ntinda as well by his LC. Your Worship, the rationale for this request and this prayer is that the residence of the surety is very important in looking up the surety at the time an accused person jumps bail, if they jump bail. If at this point of application for bail we are not sure of his place of abode, then he's not a substantial surety from the onset. We need confirmation of his actual place of abode. Thereafter we shall proceed with substantiality. The second surety, Harold, informed court that he's 40 years old and he's a farmer and is a friend to the accused person. Your Worship, the profile of the accused person as articulated by counsel for the applicant clearly intimates that he is a high-profile person who was a former presidential candidate. It is my understanding that a 40-year-old farmer who is his friend doesn't have the compelling capacity. The capacity compels him to come to court for his trial. We don't find the second surety substantial. However, in the event that court finds that he is substantial and the second surety, the third surety, good standing, can compel the accused person to return to court for his trial. In the event that this honorable court is inclined to grant him bail to the accused person, the prosecution prays for stringent terms. I disagree with counsel for the accused that the time being past 4 o'clock, granting a cash bail on him will be arbitrary. Your Worship, tomorrow is another day. If cash bail is granted, it can be paid in time from the time it's granted. I therefore don't agree with that submission. And I pray that court disregards it. We pray for cash bail to be granted to the accused person in the event that court is inclined to grant him bail. Your Worship, a cash bail that is an amount that is one that will not be underlooked by the applicant. Your Worship, there's a history in this court of persons being granted bail, given bail, cash bail, and they find that the amount is very, 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 very minimal. I they laugh it off, abscond and pay it. We pray for an amount that is substantial enough to compel the applicant to return to court for his fine. And in the event that he absconds, it is painful enough to pay it back. Forfeit the same rather. And for the sureties, Your Worship, we also pray for the same stringent obligation. Finally, Your Worship, this is a case that court needs to make its decision while weighing the rights of the accused person vis-à-vis the interests of the public. We therefore pray that one of the terms of bail should include the accused person refraining from repeating similar acts of incitement as a bid to safeguard the community and the public from lawlessness that cases of this nature lead to. Prosecution, would you please, Your Worship, their submissions are taken into consideration.
Yes, Your Worship. The first ground is neither here nor there. The person should have refrained from committing acts of incitement to violence. I wouldn't expect that, with all due respect, from the land state attorney. Yes, Your Worship. This is the reason. What I'm saying is, it's a reversal of the foundation of the Constitution on the presumption of innocence. The state attorney would like to move this honorable court to treat the suspect, the accused person, as a convict. That would be a travesty of the cardinal principle or doctrine enshrined in our Constitution, that one is presumed innocent until proved otherwise. And Your Worship, I would like to refer you to the case of Dr. Kizza Besigye on that particular principle. Dr. Besigye, Kizza Besigye, the very one before you, versus Uganda, Constitutional Reference number 20 of 2005. A copy has already been supplied to Your Worship, where a court held that the applicant should not be deprived of his or her freedom unreasonably, and bail should not be refused mere as a punishment, as this would conflict with the presumption of innocence. The refusal to grant bail should not be based on mere allegations. So, Your Worship, this is a finding or decision, a precedent of the Constitutional Court. And we invite you to uphold this, because it's binding on this honorable court. Secondly, Your Worship, the allegation that because of his stature in society, rather his station, his status in society, the accused person is likely to interfere with the witnesses or investigations. It hasn't also been substantiated. On the contrary, by the way, his stature should be used as a ground to grant him bail, that he will respect court orders, that he is a responsible person, a senior citizen. So that shouldn't be used against him. It should be used to his credit, in his favor. That a senior citizen who will respond to the court orders. And secondly, Your Worship, in the authority which is already supplied to you of Alan Sewanyana Alozias and Sejirinya Muhammad versus Uganda. It's criminal miscellaneous application number 17 of 2021. Before Lady Justice Victoria Nachintu Nkwanga Katamba. A copy already supplied to court on page 12. This point was settled. This matter was settled. Court held, and rightly so, that absence of that the applicants wouldn't, for one to allege that the applicants would interfere with investigations, that must be proved. That this must not merely be alleged, but must be proved. They cited with approval a number of authorities, including the one of Nicholas Opio, which is also cited there. And the court emphasized again by citing the precedent earlier on set by Justice Ogola, that in bail application, court should lean in favor of and not against the liberty of an accused person. And that liberty is the very essence of freedom and democracy. In our constitutional matrix here in Uganda, liberty looms large. The liberty of one is the liberty of all. The liberty must never be curtailed lightly, wantonly, or even worse, arbitrarily. So to curtail a senior citizen's liberty or any other person's liberty casually like that this is a person of high stature and is likely to interfere with investigation without any scintilla of evidence is a violation of this fundamental principle of law, which is well articulated in this particular authority. Your Worship, again, the very last authority I'm citing on that very point, which is already before you, Your Worship, Kayongo Bashir versus Uganda. It's criminal miscellaneous application 158 of 2019. On page 5, court said, if courts are simply to act on allegations, fears, or suspicions, then bail would never be granted whenever such allegations are made. The courts have stressed the point that no circumstances would warrant denial of bail on mere allegations which are not substantiated. That's the point I wanted to stress. Now coming to the issue of the two sureties, Your Worship, I was on record that the Honorable Wafula Ogutu has two residences, one in Ntinda and another one in Kitetika. And there is no crime in that. One is at liberty to have as many residences as possible. It's on the discretion of an individual. So I don't think that would raise any issue at all. The question of the ID, bearing particulars from Bujiri, we are again categorical on that issue, Your Worship. He's a former member of Parliament for Bukori Central, which is in Bujiri district. So that is his village. Many of us have got villages, Your Worship. Not everybody was born in Kampala here. So that is his home district. And that wouldn't raise any question. And I'm sure that's where he will be buried. For, yes, Your Worship, to say that is not substantial when it's not disputed that is a former member of Parliament, is a former leader of opposition, I think is to demean the status of such leaders in society. If court finds that is not substantial, when that record is not disputed, that is a former member of Parliament, is a former leader of opposition, that is not substantial, that would be undermining those particular important positions in our structure of government. Then the second surety, Your Worship, that is a farmer who cannot compel a national leader. I find that strange, Your Worship. Your Worship, I'm making my submissions. Because a farmer has got same rights as any other Ugandan. They are also Ugandans. Farmers have got capacity, and actually they are the backbone of this country. So to undermine a farmer is to set a very bad precedent in this country if it was court is to buy into that argument that a farmer has no capacity. And secondly, Your Worship, again, it's not about compelling the surety to come to court. No. The issue is not about, the obligation is not about dragging the accused person by the collar. That you must be a stout person, that you push him, you do what. Even farmers have got influence. Just reminding the accused person, or in default, to bear the consequences, say if they are non-cash bail or those conditions that might be set by this honorable court. It's not indicated that he has no capacity to bear those conditions once set. Finally, I would also want to add that I mentioned that he's a leader in FDC. He's a Deputy Secretary General. That is Mr. Harold Kaich. He's a Deputy Secretary General of the Forum for Democratic Party, which is a national political party. When I was interviewing him, Your Worship, I think. Oh, most obliged, Your Worship. I'm very grateful for your indulgence. Finally, Your Worship, that the state has invited for stringent measures. Why stringent measures, Your Worship, in a minor case like this? This is not a capital offense. We don't talk about murder, aggravated defilement, whatever. Incitement to violence. I wouldn't want to say it's a misdemeanor. Yes, it's not. But it's a very simple case. It's not an aggravated offense. And secondly, Your Honor, I took exception of that statement the state attorney made. That if bail is, if cash is not paid today, tomorrow is another day. That is to downplay the importance attached to civil liberties by our Constitution. Civil liberties are paramount. Every minute counts. Your Worship, the accused person spent a night in a very dingy police cell. Despicable. If we were to look at it, Your Worship, it wouldn't pass for anything habitable by a human being. It wouldn't pass for a police cell. Not even to the standard of a rural toilet, if you saw that particular police cell. So, and here is the accused, the state attorney having the audacity, saying, tomorrow is another day, you can always be there. So, what I'm saying, Your Worship, I pray that you be lenient, you invoke your discretion, looking at having a holistic picture of the entire case, that he is still presumed innocent until otherwise, and the fact that he's a senior citizen, and also the fact that he has gotten substantial sureties, and that he's not likely to abscond. He's around here. He can't run away from this country, and can take a judicial notice of that fact, because that's the whole essence of granting bail, that one will not run away from the country. So court wouldn't be just for the sake of punishing the accused person to impose those stringent terms. Your Worship, I would seek for your indulgence. I would humbly seek for your indulgence, that you again invoke your powers to allow the accused person say 1, 2 things himself. I will seek for your indulgence. Yes, Your Worship, in rejoinder to that.
That this person is represented, speak to him, he will get that unless he's
Your-
represented.
Your Worship,
Even I can only approve for now for his bail application.
that's the reason I was seeking for your indulgence, Your Worship.
Let me speak to you and tell court.
Court to take cognizance of matters and then before coming to this court. That since Thursday, week of course, since Thursday of 12 very violent by going to work. I was detained in my home in contravention of the orders of this court for a week. When I tried again, I was similarly detained. And at that time when I had to come down, this is where I was.
This is the ruling in this matter. The applicant and or the accused person has, through his lawyers, MS Lukwago and co-advocates, made an application for bail. The lawyer, Mr. Lukwago Arias, has presented before court grounds for grant of bail and further presented two sureties, to wit Honorable Wafula Ogutu, a friend to the accused person, together with Mr. Harold Kaija, equally a friend to the accused person, and both leaders in Forum for Democratic Change Party. Both sureties presented before court national identity cards and introductory letters from their area of residences. Whereas the state attorneys objected to surety number 1 for presenting an introductory letter from Chitetika LC1 in Kasangati Town Council, the surety informed court that he's resident of Ntinda. And whereas the surety informed court that he's resident in Ntinda Village 14, I find that the surety clearly explained to court that discrepancy when he intimated that he has a place of abode at both Ntinda and Chitetika in Kasangati Town Council. As regards the second surety, the state attorney objected to him for being a farmer who may not have the capacity to compel the accused person to attend to court once required to do so. The counsel for the accused in rejoinder submitted that the role of a surety is to remind the accused person to attend court once required to do so, and also has a duty to inform court of the accused person's absence. There being a relationship between the second surety and the accused person as a friend, I find that the second surety will be able to perform his duties as required of him. I therefore find that both sureties presented before court herein are substantial. Counsel for the accused person cited a host of authorities in justification for grant of bail to the accused person, that the accused will not abscond once granted bail, and that there is no likelihood of abscondment and interference with witnesses herein. The state attorney objected to the grant of bail for likelihoodness of interference with witnesses, given the national standing of the accused person. No proof has been provided for the same likelihoodness of interference. No proof has been provided for the same. Likelihoodness of interference is not based on mere allegations, but rather on evidence, and I find no evidence before me to ascertain the likelihoodness of interference by the accused person into investigations in this matter. The state attorney has prayed to court that in the event that court is inclined to grant bail, then stringent measures should be imposed on the accused. The state attorney submitted that there is a growing tendency of accused persons, once granted minimal cash bail, with disrepute and undermining the authority of court, having the attitude of, I can pay and get off with it. She prayed for stringent cash bail terms. In rejoinder, counsel for the accused prayed for lenient terms, but in any case for non-cash bail. Counsel prayed that court considers the fact that the accused person has prior being charged before court been incarcerated for a period of time. Now, the rationale for imposition of terms and or conditions upon grant of bail is to have a safeguard that once released on bail, the accused person should be able to attend to his trial. The bail terms are a bond with court by the accused person to ensure his attendance. This court is enjoined with a duty to ensure administration of criminal justice in a manner that balances the interests of both the accused person's right to liberty and that of the public. The accused person is charged with the offense of inciting violence. Whereas his right to liberty ought to be protected, the right of the public to enjoy their other constitutionally guaranteed rights without interferences ought to be protected as well. Now, in the result, and considering the foregoing, I hereby grant to the accused person bail in the following terms. The accused person is granted a cash bail of 30 million shillings payable to the bank, details of which shall be availed. And each of the sureties is bonded to 70 million shillings, that is non-cash. State. Date. Date. Which date? So this matter is adjourned to the 16th day of June at 9 for mention, and the accused's bail is extended until then. Court is adjourned.
Extremely unjust, to say the least, glaringly outrageous, with all due respect. It's really outrageous. It's a miscarriage of justice, a travesty of justice, because she recognized the fact that the accused has got a right to bail, the fact that he is a senior citizen, he is still presumed innocent until proved otherwise, he has got substantial sureties, he is a person who is not likely to abscond from the jurisdiction of this honorable court. All the grounds were upheld. Not even a single ground was defeated. But we were shocked. This was an irony. That notwithstanding, she goes ahead to impose astronomical figures, sums, to the tune of 30 million, even after explaining to her the circumstances and the kind of mistreatment he has been subjected to. That for all this long, he has not been working. He has been in running battles with the police. His movements had been curtailed at home. Actually, he's not working. He has not been allowed even to get out of his home. He's not been allowed to move an inch from his yard, from his home. So, all of a sudden, without any justification, you impose such outrageous sums in cash bail That's why we are saying this is a travesty of justice, it's a miscarriage of justice, and our client is extremely aggrieved by that decision. Actually, he's baffled, he's perplexed, he's vexed, to say the least. He's vexed, perplexed, and baffled by that ruling, by that decision. And for that matter, he has taken a stance of not soliciting for any help to pay because he does not have the money. He can't even be allowed to access anything that would help him, say probably sell one of his property. He cannot do it. So definitely he's not going to pay it. And he has instructed us to immediately file an appeal in the Court of Appeal to challenge this decision. It's unfortunate that it's a laborious process. It's going to take a bit of time. He will be on remand as we pursue the appeal. That's the unfortunate bit. But he is still strong, and you know him very well. He's not about to be in any way heartbroken or to have his spirit punctured in any way. So we are going to do that right away. Hopefully by close of business tomorrow, we shall have filed the necessary papers in the Court of Appeal, rather in the High Court, to seek for revision of this particular decision. This is a matter which is revisable by the High Court, and we are going to do it right away and seek for quick and expeditious disposal of the same. So basically that's what we are going to do. Decision yene mumazeeko kye bayita ebyewungula. Emwewunyisizza nnyo naffenna. Etwewunyisizza nnyo. Tugamba tuli mu kkooti, etunulira amateeka, etunulira ssemateeka, neeramula obwenkanya, oba tuli mu kintu kirala. Kubanga kana akasango ke bamutaddeko katini nnyo, si capital offense nti oba murder oba aggravated robbery, sibyo. Kasango mu incitement to violence mbwa yabadde akuma mu bantu omuliro, tekanawulirwa nakuwulirwa, bagambye bakyanoonyereza. Noga nti kituufu omumanyi bulungi nti muntu wa buvunaanyizibwa, mukulembeze atabuusibwabuusibwa mu Uganda, era muntu wa buvunaanyizibwa alina amaka, alina basurities oba bazze omwemirira, noga bonna tebabuusibwabuusibwa credentials zaabwe, bali substantial. Era n'ogamba nti tewaliwo na nsonga yonna eraga nti bwe banaamuwa beiru ajja kudduka. Ebyo byonna akkiriziganyizza naffe nti ajja kubulawo singa kkooti emutadde. Ate n'omaliriza n'omugamba sasula obukadde 3 tulyoke tukute. Kwegamba kikwewuunyisa. Eyo kkooti etumazeeko ebyewungula. Omulamuzi atwewuunyisizza nnyo. Tumuwa ekitiibwa naye ensalawo ye tetugiwa kitiibwa. Ye ng'omulamuzi tumuwa ekitiibwa naye ensalawo ye tetugiwadde kitiibwa. N'olw'ensonga eyo Dr. Besigye anyoleddwa nnyo olw'ensalawo eyo, emwewuunyisizza, era n'atulagira amangu ddala nga bwe kisoboka tweyongereyo mu kkooti esingawo okujulira ku nsonga eno, era ye mweteefuteefu oga nti kale ajja kugira abeerayo ku remand okutuusa nga apiiru emaze okulirwa. Kyekyennaku nti eyinza okutwalako akadde, naye ffe obutasukka nkya empapula tujja kuba tuzitutteyo mu kkooti. era olaba ebintu bino byabadde choreographed nga babikoze baluddewo kumuleeta batubingisa batuzza wano batuzza wali kooti etudde ku zino ku sawa nga ziyise ne mu 11 okuwa rulingi nga ne banka ziggaddewo gadi byonna biraba nga byabaddemu okupangirira era kyannaku nnyo era tusaba abakulembera ekitongole ekiramuzi nti oba bino byonna mubiraba gye bikomye gye bitwala eggwanga n'ekitongole ekiramuzi nti kisobola okukozesebwa okukola ekintu ekifaanana bwe kityo omulamuzi n'atuula wano n'okwata peni n'owandiika n'ogamba omuntu ali ku kasango ka incitement to violence nti sasula obukadde 30 23 obuteekeyo wano ku kasanga akafaanana bwe katyo. So tugenda kujulira kubanga si kya bwenkanya. Ensonga zonna tuzimubuulidde omulamuzi nga tulowooza jaziwa ekitiibwa kubanga ensonga ze tutadde zirimu eggumba naye akkiriza nti kumpi gubadde gugenda kuwera mwezi nga Dr. Besigye tebamukkiriza kuva waka takola. Buli lwabadde agezaako okufuluma ewakaawe emisanvu nga giri mu kkubo ng'abaamu ekiise odda bataddewo agamotoka bamukunguza bamuzizaayo bamukoze kino bamukozeeko ebyambyone buli kimu tebamukkiriza kufuluma bweru so nga takola. Ne tumubulira n'omubulira nti tabadde takyafuna na kyakulya ewakaawe. Ebyo byonna omulamuzi n'abiteeka ku rekoodi ate tebiwakanyiziddwa state attorney. So byonna abimanyi. Kati ogamba otyo omuntu abadde takola, omuntu asibiddwe waka, omuntu kati gwe babadde basibidde Naggalama, omuntu gwe bamazeeko obwetaayizo bwonna nti leeta obukadde 30 kikulaga nti waliwo ekkobaane kyannaku nnyo ekkobaane wakati wa state n'ekitongole ekiramuzi ku nsonga eno kyannaku nnyo mu ggwanga lyaffe ekyokubeerawo. So tugenda kutwala okujulira okwo era obutasukka olunaku olw'enkya. Well, abalala kyebasoose okutukola kwe kubaawulayawulamu kyatwewunyisiza tebatuwadde na charge sheet ne bagamba nti ate mukaaku bamututte eri side endala Kato bamututte kugwa traffic ne bagamba Kato bamuwadde beru ya $1,000,000 cash. Mukaaku ne bagamba bamuwadde beru ya non cash. Kakati kooti zezimu be bantu be bamu babakwatidde ku mbeera yemu ate